Teach and share week 8, chapter 16, copyright law. So do you have any understanding of copyright?
Copyright is a protection for a book, for music, for even like symbols of businesses.
So the framers of the U.S. Constitution saw how important it was to protect original works by authors and creators. So in Article 1, Section 8, it authorizes Congress to create laws that will protect original expressions expressed in a tangible or physical form. So, a copyright is an exclusive right granted to authors on their original work to have it reproduced. So it includes literacy, dramatic, artistic works, stuff like that. But you were right that it goes further into like books and music and stuff like that. So owning a copyright gives the right to copy to the holder. The Copyright Act of 1976 says that the copyright law is for both published and unpublished works. It also gives power to the holder to reproduce, distribute, which means sales or licensing, create derivative works that are based on the original, so they can kind of expand a little bit, do a little bit of changing, and display and perform the works as well. So protection is given to the holder so others can't do those actions. Yeah. So it's like, you can't, no, stop, hold.
They have to do that at Hillsong Theater, do you know that?
Mm-hmm.
If they want to change anything,
they have to,
play.
Yep. So copyrightable works include books, dances, songs, movies, art, menus, and computer software, which I didn't realize computer software was one of those, but then I'm like, oh yeah.
Makes sense, but I didn't either.
And originally it didn't used to be a part of it, but then things changed and they made it so it was part of the things that could be copyrighted. So there are 2 requirements for a work to be protected. So copyright law only protects original works of authorship. So copying information that is common knowledge is not the product of a creative process, so it can't be copyrighted. So titles, names, common phrases, or slogans can't be copyrighted. As well, what is copyrighted in the manner in which the idea is expressed when it comes to mathematical expressions or ideas, so they can't really be copyrighted as well. Does that make sense? Only the tangible form of the creative expression is subject to copyright. So, if a speech is given, it doesn't become copyrighted until it's in tangible form. So that means it's been recorded or filmed, something like that. So that will change.
So just writing it down doesn't...
Correct. Most speeches may still be copyrighted under certain circumstances, but majority of the time it has to be tangible. Well, if it's oral, unless it's been recorded, technically writing it down sometimes can be, but there are certain requirements. So, once an original work is created, then it's tangible and can be copyrighted. So that means authors are not required to register their work with any government office, like it is required with patents to assert what their rights are under the law. So it's difference between patents and copyrights, which I understood a little bit of, but now I understand better. So registering a work through the United States Copyright Office and the Library of Congress gives a lot of benefits to the author, such as public record of the copyright and the ability to use for infringement in case infringement cases come up. So I didn't know how it was a simple process. I didn't know that it was only like $35. I thought it cost more.
Yeah, isn't that crazy?
I was like, oh.
So that's more than it was last time I studied up on it.
But yeah. I was so shocked. So according to the Sony Bono Copyright Term Extension Act of 1998, it has set up protections for anything that was created after January 1st, 1978, and will last for the life of the author plus an additional year. So it expanded the time frame of how long it could be copyrighted. So I didn't know that either. And the length of a copyright is not always so generous, and previously Congress extended copyright terms, which I didn't know happened a lot with Disney. They kept changing, kept extending. I'm like, oh, that's interesting. Do you have any questions so far? No. Is it making a lot of sense?
It is making sense.
So when a form or expression of an idea is copied, that is when infringement happens, even if it's not 100% the same. So, when a substantial part is reproduced, infringement happens. But unfortunately, Congress has not given a real definition of what is considered substantial. It's up to juries to determine. So it could be 50%, 20%, 10%, 5%. The juries will determine. And I kind of wish that they would be more firm in that, but they're not. So it's kind of like a gray area. So with that, direct infringement is easy to prove. So copying a DVD, back in the day, that's easy. Whereas indirect infringement is a bit harder to determine, but will occur when the infringer copies parts of an element of the work, parts or elements of the work. So when this occurs, the copyright holder has to show the following: that the infringer had access to the work and that they engaged in sufficient copying that would constitute substantial similarity between the works. So there has to be a lot of similarities. So this type of analysis to determine how much infringement is will happen when there's similarities between songs. How many lawsuits have we seen between artists because their songs are so similar? How many have won? How many have lost? I didn't realize until I was looking this up that I'm like, oh, there's been a lot. Like I've known of I think there was Taylor Swift one, and I think an Ed Sheeran one, and other artists, and even artists back in 70s and 80s, so I didn't realize that that's what they determined, how far it went. So those who infringe could be liable for damages and even face criminal charges for prosecution in some cases. So actual damages could occur, which is the amount that the copying costs the holder in profits or the amount that the infringer profited from the copying. And additionally, copyright law will provide for statutory damages that the holders, or the plaintiffs in the case, can seek in replacement of actual damages. So it allows up to $35,000 per infringement and up to $150,000 for willful infringement. So that means they willfully did it, So there is the fair use exception. Have you heard of that before? Mm-hmm. So a lot of times I watch a lot of videos on YouTube of reacting to certain things. So those YouTubers have fair use exception to use some of that copyrighted material. It's like bits of another movie, bits of a news story, but they can't have the entire thing in there. So this is how you can avoid liability for infringement by using the fair use doctrine. So basically it allows people or entities the ability to use or reproduce copyrighted materials without getting permission or even paying licensing fees. The misconception with this is that the amount that can be used or permitted. The Copyright Act states that fair use for purposes of the following is non-infringement of the work. So criticism, comment, news reporting, teaching, scholarship, research, stuff like that. So when I said YouTubers, reacting or commenting or criticism to a certain extent can be covered by that. So determining whether the use of the copyrighted works qualifies for the fair use exception, it requires the following factors, and they kind of have to be balanced, So the purpose and character of the use. Is it for commercial use or education? So commercial use would be infringement. Educational purposes would be fair use. The nature of the copyrighted work. Is the copyrighted work educational, which is fair use, or entertainment, which is infringement? The amount of the portion used in relation to the copyrighted work as a whole. Was a little bit used or was a lot used? Mm-hmm. And then the effect of the use upon the potential market for or value of the copyrighted work. So again, dealing with the money and stuff like that. So these are set up to be vague, unfortunately. It'll be up again, like it was with the other, to the jury to determine how to weigh all of them, on a scale. What, does it lean this way more? Does it lean that way more?
We had a case in Utah like that. Do you remember that theater we used to go to downtown?
Yep.
They got in crosshairs with Star Trek.
Yep.
And so it was a huge mess.
Yeah, you have to be really careful. You can do it to a certain point. So again, it's up to the jury to determine whether infringement did occur or fair use was given. So, of course, the importance of copyrights is important. The value is high for protection. You want to protect your work. So the following rely on copyright protection. These type of businesses are people, churches, universities, nonprofits, accounting firms, other types of things. So the balance of how much we as the United States should protect holders is still debated to this day. But it's clear the copyright does create protection that is valuable for a real asset. So when I was reading this, one of the quotes that stood out to me, what was the actual definition, what the direct quote was on what Congress would do. It says protecting original expressions expressed in tangible form. So it basically says this is what it is. There's no middle gray area on the definition. So there's that we have to look forward to on that, but then other areas are gray. So this week in my international business class, because we're starting our second project is all about setting up our product that we want to market. So we have to come up with a brand name. So then we have to be careful with copyright. We can't use something that's already been copyrighted by another company. So I thought it was interesting that knowing about this will help me understand what to do for that class. But then also knowing about copyright laws will set me up for future when I'm working in a business, whether if I own the business myself or I'm working in another business, to know what I can and can't do for that business. Can I copyright this? Can I use this? So I thought it was interesting because I knew some of the basics, but not all of the basics. So
Very interesting.
do you have any questions? Did you learn some?
Yeah, I did. There have been some changes since last time I
Yeah. I also thought about, because I was talking to you about this, about the whole copyright dispute between San Diego Comic-Con and Salt Lake City's Comic-Con FanX, and how that was an ongoing process. And I'm still fascinated by that case because I'm like, it didn't make sense why they went after one and not the all, but I don't know. It just,
because Salt Lake was making so much money.
Yeah.
That's why.
it was cool,
It
but
always comes down to
to the money.
the money.
Yeah. Well, thank you so much.
You're welcome. Thank you.